Welcome to the Fearless Floyd Show. We'll begin in 2 minutes. Uh, Trust, part 19 of 24, without a subtitle.
Cool, huh?
All right, panel 2. Parties in a trust agreement or arrangement. I'm sorry. I know I keep going over this again and again, but there are still some issues concerning the beneficiaries of the trust. Some people are still creating their trusts and naming themselves as the beneficiary of their own trust. Trusts are distributed once the grantor, settlor, trustor are dead. How can you benefit from the trust as a beneficiary if you are dead?
Good question, Floyd. I always wondered that same question. Everybody seems to want to be a beneficiary. Guys, that's not who we are. We are either the grantor or the trustee, one of the two. We can't benefit from our own trust, plain and simple.
All right. Good. Panel 3. Usually, at least 3 parties are involved in the creation of a trust. Those parties are the settlor, truster, the trustee, and one or more beneficiaries. In cases involving testamentary trust, the settlor is referred to as the testator. 3 different individuals do not have to be involved in the transaction in order for a valid trust to be established. For example, one person can serve as the settlor and the trustee. If a self-settled trust is involved, it is possible for one person to serve in all 3 capacities. Ooh, now that's going to create a firestorm right there. I already see it. Matter of fact, I got
there is stuff called self-trust, and there is something that is a self-trust.
I came
You
prepared.
can do it for just yourself.
Got my
Boston
books.
Fire. Oh, we're ready to put it out.
I'm prepared. Ready to battle.
That is something we don't see very often. But in certain situations, I have literally seen a person just create a very small trust, and it was a self-settling trust for himself, so he could settle something with somebody else. And he needed to be the creator of the trust. He needed to be the trustee of the trust, and he benefited when he settled it. It was a disagreement settlement. So this is how he got away with it. But normally we don't get away with stuff like this. So I wouldn't actually try to do that in your own trust. Be honest with you. You do at least need to be the trustee and the grantor, but you should never be the beneficiary. Never. Because how are you going to benefit when you die? End of story. You're creating that trust to leave behind. You're not creating that trust for yourself.
Right. Well, yeah, yes and no.
Well, okay, you are creating it to protect yourself,
Yeah.
but in the end, you're creating it for your legacy to leave behind. So
Right.
that's why I say you're not actually creating it for yourself. So you should not benefit from it. While you're alive, you can use the trust and take the benefits from the trust. But when you're gone, you do need your beneficiaries, because they're going to get your benefits as soon as you die.
So be kind of like creating a ghost. And that way your ghost still stays around and haunts your beneficiaries, your heirs.
Ooh.
Yeah. All right. Oh, Halloween's over. Damn it. Missed that boat.
Oh.
Day late.
Well,
Doc.
yesterday was our Day of the Dead here in
Right.
Tahiti. Yesterday was our holiday. Yep, everybody had to go to the cemetery, light candles, put the white salve on the graves, put the candles out, put the flowers out, do all those things that they do. I guess that's why I don't like graves.
Oh yeah, I knew they were going to blow them out tonight. We're watching the Astros. It's 5-0 Astros.
Oh,
Okay. However, for the trust to be valid, the trustee must owe equitable duties to someone other than themselves. Thus, if the settlor is also the trustee, you cannot be the only trust beneficiary. The settlor trustor is the person who creates the trust. Since you are the person who established the trust, you are the settlor or trustor. Choose whatever title you'd like. The third party who manages the trust is the trustee. The trustee may be an individual or a corporation. It could also be an attorney. The settlor may select one trustee or several trustees to manage the trust.
so guys, it's just basic logic. It's really totally logic. If you are the grantor, then you can literally, if you don't want to manage your own affairs and you want somebody else to do it, then you hire somebody to do it. Otherwise, you do it yourself. But you definitely are going to have to name a beneficiary. It's the end of story. Otherwise, the state gets it all.
Yep. All right, panel 5. The trustee may be appointed by the trust instrument or by the court. The person or entity appointed as trustee must affirmatively accept the role. Once the trustee accepts the appointment as trustee, the person can be released of the obligation only with the consent of the beneficiaries or by a court order. The trustee is entitled to receive reasonable compensation. A trust will not fail for lack of a trustee. If the trustee dies and no successor trustee is named in the trust instrument, the court will appoint a successor in trustee.
So guys, what it's talking about is if you fail to appoint a trustee, or if the trustee, now that you're dead, tells the court, okay, I really cannot handle this. It's too big of a job for me. I thought it would be fine in the beginning. So you can decline. You do not have to accept it. Now, if you were the trustee, you should have a co-trustee or a successor trustee set up in your trust. If you failed to do so, the court will choose one for you. And it could be a court-appointed administrator to administrate your trust, or it absolutely could be a family member. And maybe it's not the family member you want to administrate your trust. So it's a good idea to name a few people.
Yes, absolutely. Trustworthy people. Panel 6. However, if the trust instrument or other facts indicate that the settlor chose the person to act as trustee because of the nature of their relationship, the court may conclude that the settlor would not want the trust to continue without that trustee. As a result, the court may dissolve the trust on the death or resignation of the trustee. If the trust is created as part of a will, the executor can also serve as the trustee. The trust instrument must give the trustees some active duties to perform.
So basically, when you're setting up your trust, if you have a really good relationship with the person and he passes on, the court can, say, okay, well, now it's, instead of the trust, continuing on, it's going to be a dead trust or a irrevocable trust that we are going to clean up or, settle out or whatever we're going to do with it. So you have to be careful when you're writing your trust. That's all I can say. You have to understand the different laws of your state. Different states have different laws, especially trust laws, and especially laws for executors, especially laws for wills and things like this. So just take into consideration and take about half an hour, 45 minutes, maybe an hour, maybe a day, depending on how much you can research and how much you can understand to figure out the laws that apply to you before, naming the people in your trust.
There you go. Be patient. Panel 7. A settlor who gives the trustee no managerial responsibilities creates a dry trust. As a result, the court will not recognize the creation of the trust, and the beneficiary will receive legal title to the trust property. The trustee has legal title to the trust property, and the beneficiary has equitable title. Consequently, the trustee has the managerial authority over the property. The beneficiary of the trust is the person who receives the benefit of the trustee.
Okay, guys. So basically, when you're writing your trust, what this is legally or literally saying is, if you don't name what the beneficiary or what the trustee is and how it's set up and what his responsibilities are, it's called a dry trust. It doesn't matter. It has nothing in it for a trustee to do. So this is when somebody has to step in. And if the court has to step in because you didn't write your trust correctly, you might not get what you had in mind. So it's very important to understand that you literally have to lay out everything inside of your trust.
Absolutely. All right, panel 7. Panel 8. Oh, that's a new panel. Oh, hey, remember when I cut my hand?
Yeah. Oh, wow. That looks real good.
Uh-huh. That pretty good, didn't it?
Guys, that was a trust paper cut.
Yeah. Joe must
He
go
got
on.
mad at his trust.
Okay, panel 8. Well, come on, panel 8. There we go. Creating a private trust. The two major categories of trusts are private trusts and charitable trusts. There are no magic words that the settlor has to use in order to establish a trust. If it looks like a trust and functions like a trust, it is a trust, regardless of what the testator calls it. First, The testator must manifest the intent to create a trust by vesting the beneficial ownership of property in a third party or in the settlor for the benefit of another.
Gee, doesn't that sound like if it looks like a duck and quacks like a duck and walks like a duck, it's a duck? Okay, let's go on. So basically, we do have private trusts. Private trusts are in the private sector, and charitable trusts are in the public sector. So if you want to create a charitable trust, it's going to be out in the public sector for everybody to see. If you want your own trust, it can be in the private sector and nobody can see it, because trusts or any trust, people are not allowed to see them.
Right? All we need to see is a certificate or declaration of trust. Panel 9. Second, the trust instrument must name ascertainable beneficiaries. The class of beneficiaries must be so described that some person might reasonably said to answer the description. Third, the trust must be funded with property. There must be an identifiable trust res or corpus. Any form of property, including stocks, real property, mortgage securities, easements, causes of actions, can be the corpus of a trust as long as the settlor has an interest in the object.
So guys, we don't name prices, we just name objects, or we just name titles of our objects. So when it's saying that we must name our beneficiaries, then it literally says we have to make sure they understand that they're a beneficiary. So that's what ascertainable means. When they read the trust and they start going through it after you're gone, it's pretty easy to understand who the beneficiaries are and what their benefits are from the trust. So be careful when you're writing it and make sure that you change it around. Don't forget, guys, you can make amendments to your trust. Once you write it and things change, or you decide to change things around, you're free to do so.
First, just write it. Just write it. It doesn't have to be perfect. It doesn't have to have proper grammar, proper spelling, proper punctuation, none of that. Just write it. Then go back and reread it and edit it. Just write it out. Even if you gotta hit dictate on Microsoft Word, which I like to do, and just like speak into your microphone, man, that works great. No biggie. All right, we're gonna move on to panel 10. In general, a trust does have, let me restart that. In general, a trust does not have to be in writing to be valid. Thus, the settlor can create an oral trust. However, the Wills Act mandates that a testamentary trust be in writing, and that the statutes of fraud require an inter vivos trust of land to be in writing. As a result, the only trust that can be oral is a trust that disposes of personal property. Proving the existence of such a trust is difficult because the parole evidence rule limits the extrinsic evidence that can be admitted to prove the terms of the trust, not that exculpatory evidence.
Okay, guys, recently more and more people are wanting to film their trusts. There's starting to be, what is it? No, I wouldn't say hieroglyphics. It's not. Oh my gosh, I forget the name of it. It's where you can film and it's like you're a real person and you're standing there explaining your trust to people, you're moving around and you look like a 3D animated person and stuff like this.
Hologram?
A lot of people, what?
A hologram?
Hologram. Yeah, holographic, that's it. There's a lot of people out there that are starting to use holographic trusts. You can get away with that, for your personal properties and stuff like that. But like titles and stuff, they still want a written instrument.
Holograph. Yeah, you just like went way over everybody's head. Yeah, you just got like a Michael Jordan finals dunk. Sorry, everybody. I didn't mean for her to do you.
Oh, well, that's what it means.
Yeah, I know, but now they're all gonna go look up holographic trust and want one of those, and I don't have one.
Guys, they cost a fortune. If you really want to film a holographic trust, go for it.
Yeah,
They're absolutely expensive.
right. Yeah, the Joneses don't
They're
have
only actually for the eccentric, is
right.
how I see it.
Right. Yeah. Well, the Joneses don't have one either, so you don't have to keep up with them.
Oh, that's good.
Yeah. Intent to create a trust. It is not enough just for the settler to use the word trust. The test is whether the settler indicated that she intended to establish a trust relationship. It is well established that in construing a will, a court must attempt to give effect to the intent of the testator. Where there is room for construction, that meaning will be adopted, which favors those who would inherit under the laws of intestacy.
Yeah, it gets complicated in court cases, especially if your will is so, I guess, legalese and legalized and legal this and legal that, and you try to be, so professional about it. Sometimes judges, who hear this all day long, they have no clue what's going on, because I'm learning that a judge does not make any rulings unless he's got an order in front of him and he can make a ruling on it. So you literally have to tell him what to do. And if you can't tell him what to do, he has no clue what to do. And it's got to be somebody else who will step in and say, well, I need to make a motion to have this changed. And okay, now I'm going to make an order so you can do this. And then the judge can act on it. So keep in mind, judges just sit there to listen, and they need to be told what to do. So when you're writing these things, make sure you tell the judge what to do.
Right. There you go. Okay, panel 12. Before a trust will be found to exist, there must be a clear manifestation of an intent to create a trust and not to do something else. A testamentary trust will not be declared unless such trust is clearly intended by the testator. It has generally been held that an imperative command to dispose of the property for the benefit of another is required to create a testamentary trust. Precatory words are not enough to create a trust, and if the grantee has discretion to use the property for herself, the court will not find a trust. Precatory words? Precatory.
I love this. This is fun.
Yeah. Well, I see that reading coming out. Am I pronouncing that
Okay.
correctly? Because to my knowledge, I've never seen that word, precatory. I could be saying it incorrectly, and then we have the whole French English translational dogma happening.
Okay, so we have our manifest. Everybody knows how to manifest, or is that something new for people? When we think of something we want and we sit there and dwell on it, dwell on it, dwell on it, and all of a sudden we're starting to see it form. That's a manifestation. We're starting to manifest our ideas and we're starting to form them. So when we start to write our will or our trust, we have to sit there and we have to think about it, which is our manifestation process. And we start manifesting what we want and what we're going to see in the end. And once we understand how to manifest it, then we understand how to write it.
Mm. Okay. Can you see my screen?
Well, everybody's going to be starting to learn how to manifest more and more as we move forward. We have to.
Oh, yeah, I get it.
Yeah.
My screen did share, so I went from that to that. So let me go here back to 19. Okay. All right. And panel 13. In determining the intention of the settler, the following circumstances, among others, are considered. The imperative or precatory character of the words used. And I just looked up the definition of precatory for you guys, and I believe it was on the screen. Number 2, the definitiveness or definitiveness of the property. The definitiveness or indefinitiveness of the beneficiaries or the extent of their interest. I want somebody to say that fast 3 times. Number 4, the relations between the parties. Number 5, the financial situation of the parties. Number 6, the motives which may be reasonably be supposed to have influenced the settler in making the disposition.
These are all things they rule on, guys. Everything that we're looking at are different things that they rule on. They look at what our intentions are, how we, created them, what type of person we are, how our relationships are, and what our motives are. So it's really important, especially in trust, because there is some people who go out and try to, defraud things by putting stuff in trust. And I keep telling people, if you have a problem with your property, there's a lien on it, don't think that you can lock it up in a trust and Dakota. Sorry about that. Don't think you can lock it up in a trust and get away with it and keep it, because that's fraud, guys. You have to take care of the problems and clean up the mess before you can move stuff into a trust.
Right. Okay. Number 7, the final one, whether the result reached by construing the transaction as a trust or not a trust would be such as a person in the situation of the settler would naturally desire to produce. In order to ascertain the testator's intent with regards to creation of a trust, courts often look to the plain language of the testamentary instrument. Although it's not necessary for the testator to use the word trust, the use of that word usually leads to the conclusion that the testator intended to create a trust.
I always tell everybody, put it in your trust. If it's a revocable trust, make sure they know it's a revocable trust. If it's an irrevocable trust, make sure they know it's an irrevocable trust. It's not that big of a deal. All you have to do is, irrevocable trust, you can name them anything you want. A revocable trust belongs in your name. And it's very simple. You have one revocable trust and the rest are irrevocable. So when you create them, make sure you put the correct things in the correct place. So you wouldn't really want to move a car into your revocable trust, because a car could have liabilities, and you don't want your revocable trust to have those type of liabilities. So you would more than likely create a separate trust just for your car, so that trust is the only trust that handles the liability. That saves your assets and your liabilities.
Absolutely. All right. Make sure I'm on the right panel. Yeah, panel 15. If the language of the testamentary instrument is unhelpful, courts will admit extrinsic evidence to determine the testator's intent. That evidence infrequently includes the testimony of disinterested parties. It has been noted that the use of precatory rather than mandatory language does not create a trust. The court may permit a trust to be established from precatory language if the words taken in connection with the other portions of the will and in light of all the circumstances indicate that the testator intended to place a legal obligation on the potential trustee. What factors should be considered to determine if a precatory trust was intended?
So basically, this all goes back to the court systems. If you write your trust correctly, don't really have to go through a court. If you mess it up and there's problems and the trustee is having issues and the beneficiaries are fighting over the trust because you didn't write it correctly, then they end up bringing it into the court system. Then you have to find people who are who know the family, who understand the person who's not there any longer, who have been close to that person and can vouch for what that person's intentions were. And then the court rules on that. So just be careful when you're writing this, guys. It's really important. Don't get, fancy with the handwriting. Don't get fancy with the words. Just keep it simple. Use the KISS. Keep it simple, stupid.
Exactly. Keep it simple, simple, simple. As you grow with knowledge and wisdom and experience, that will grow. Your trust will grow. Your words will grow. Your definitions, your vocabulary, et cetera, et cetera. All right. And last but not least, the conclusion. It is important to understand how trusts work, what we need to create a trust, understanding who the beneficiaries of the trust are. If there is a dispute concerning the trust, when you are no longer here, how a court will regard the trust and the language you use to create this trust. There has to be certain intentions in a trust to consider it a legal and binding trust. Keep in mind, you do need beneficiaries for the trust, and you are not one of them. You cannot benefit from the trust when you are gone. Thank you for hanging around after the show. I want to present to you Tailor-Made Trust, featuring LeFlore's Trust Series, available at tailormadetrust.com, as well as the fearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA trust addendum. And as always, LeFlore's classic trusts and ancillary classes, and also Anne's books on trusts and specialty trust, which I also co-authored. If you'd like to get a class, a book, or have a trust custom built for you, always available at the fearlessfloydshow.com store. And I'll see you in the next show. Thank you for watching and have an awesome day.